Assalamu alaikum. Today we have been listening to an awesome segment of sessions which describes what a will is actually. We often hear about will and we think that it is just a simple document and is to be executed concerning our desires to be given to the ones that we love. But in fact, will is a four-lettered word which is very simple to hear and write but has got big implications. And if not a lawyer, legal professor, writer, and a very well-known, renowned public speaker, it is always pivotal that when we learn about the legal aspects of anything, that we have expertise or we get to know more about it from an expert. And I take this opportunity on behalf of the entire Merchant Foundation to warmly welcome you and to hand over this dais to learn more about and comprehend what will is according to the Canadian law.
Because facts of each individual's life vary significantly. So there's no such thing as a generic standard will. Unless your life is very simple, you don't have assets, you don't have certain types of assets, you don't have children, you don't have things like that, then you can do just a simple will. Unfortunately, money corrupts people. Okay? I've had situations in our community, very close family. Many people know them, 5-time daily prayer people in the masjid. Okay? They die, the father leaves a big estate, and the mother right now, okay, is living in at that time, this is what, 5 years ago, $70,000 condo. The kids fought over $2-3 million in assets. Okay? And doing these things in advance, I see it personally. I've done this for 24 years. The amount of stuff that I've seen in the community shocks me. Right? I don't expect that, but it happens. And we used to say, it won't happen in the Muslim community. Of course it happens. Every single ailment that's out there is in our community too. It's just hidden a little bit better, unfortunately, right? Okay, so assets of a business dealt with under a partnership or shareholders agreement. So if you have business interests, you might have a partnership agreement or a shareholders agreement. You need specific legal advice how to figure it out, how to structure and deal with it in a will situation. Trust agreements. A lot of people do trust agreements. Again, that's what when you talk to a lawyer, they might advise you to do trust agreements for certain things. But then when you do the will, there's implications for that. Or even when you come to the lawyer to do the will, they might advise you need to do trust agreements maybe for certain things. Okay? Assets dealt with a marriage contract. You may have already dealt with the marriage contract. So just like the prior legal agreement, you can now discuss it in the will because you already have arrangements set up in a marriage contract. Challenged by dependents. So even though you write a will, dependents can challenge it. They can say, well, I don't want this. We're beginning to see that when people are structuring, what they think would be like an Islamic will. So they give 2 shares to the son, for instance, right? So now it's going to get challenged. It's being challenged, right? Some daughters will come forward and say, why am I getting half the share? So limitations on a will, other limitations are, there's no complete power of disposition. What does that mean? A will doesn't allow you to distribute any way you want. There's restrictions. Okay? There's limitations. So Succession Law Reform Act says dependents, spouse or common law spouse, parent or grandparent, child, grandchild, brother or sister, provided that the deceased supported them, they may be entitled to shares. Okay? And there's a very technical rules about who gets what. Okay? Also includes a person whom the deceased demonstrated a settled intention to treat as a child of his family. So it may not be your child, but maybe you treated the person as a child, you supported them, you gave them educational funds, whatever, food, blah, blah, then they may come forward. So under the Succession Law Reform Act, certain people have rights to claim. Right? The will, now you pass away, the spouse has 6 months from the date of your death to elect. Yes, I will listen to the will and I will respect the will. I want exactly what I'm given under the will. Or the spouse can say, I get more under the Family Law Act. I don't want to apply the will. Okay? So the choice is there. They can elect. So if the parties respect whatever intent, that's why it's important to have a conversation with your spouse or whoever it is that you're doing this with. right? So we've had a chat in our family. We had a chat. My parents sat us down and said, you know, you have a problem if anybody have a problem if all the kids get equal shares? We all said no. So we expressed our intention. We clarified our position on it. So we know our parents want, even though our daughters and sons, equal, because we've agreed to that, right? So these kind of conversations are uncomfortable, but I think you need to have that if you want to keep the family together later, because these are the kind of things that then shatter and create litigation, right? A lot of litigation. And then of course, if you want Islamic rules of inheritance applied to various lengths, then again, you know, there's some limitations in a will. So you may have to work outside the will to structure it that way. Next. So what happens if you don't have a will? Okay, there's a lot of fear. People say, oh, if I don't have a will, the government will take all my property. Okay? No, that doesn't happen. Okay? So don't worry, government's not going to come in. Imagine if they did that. There'd be uproar, right? People will be like, what? If I die and I don't have a will, the government takes my property. No, they don't. Okay? They go to the Succession Law Reform Act. And there's a list of people who get. Okay? A list of people who get it. But first thing is, if you die without a will, somebody has to be appointed your executor. If you have assets. If you have no assets, nobody will care, right? Nobody will come forward. Okay? But if you have assets, then somebody will come forward. Somebody from your family has to come forward and say, I want to be appointed the executor. So you'll go to a lawyer's office and say, look, so-and-so deceased, they didn't have a will. What should we do? So they'll have a conversation with you, get all the information. They might tell you, don't worry about it. They don't have really any assets. It's not worth spending the money to be appointed executor. Or if they say, oh, look, you have all these assets, these business interests, or problems, or whatever it is, okay, then you want to be appointed the executor. Then we would do an application to court. It's called probate, estate probate, and we would apply to the court for that person, whoever comes forward. Usually it has to be a close sibling, you know, family member. Okay? Then the beneficiaries, if there's no will, the executor will be appointed. Then we look at the provincial law, which says these are the beneficiaries. Who are they? They're going to be the spouse, the children, okay? And you know, parents, siblings, etc. They go down the list. Once everybody is exhausted, about 14 different categories of people are exhausted, then the government will take it. So if you have nobody but your long lost second cousin from Kerala comes, they can take it. Okay? But if nobody comes, then the government will take it. Agreements now? Because no, he told me I should get this much, right? The fights happen, so of course there's delay in that. Increased legal costs for that. Public trustee will control shares of minors. So if there's minor children involved and there was no will left, the public guardian and trustee will get involved, right? Which is the government. Then everything you do has to be run by them. They have to approve it to see if it's in the best interest of the child. Issues about your spouse, they had some trouble, they had some psychological problems, for instance, okay? So they can't get the kids until they clean up the situation. So the court will step in, the government will step in and appoint a guardian, right? So with a will, you can control all that. Without a will, you have other people doing it for you. Potential increase in taxation because you didn't structure your estate properly. Okay, so just before that, will, then, as I said, whoever gets appointed becomes the executor. All those other things I mentioned before happen. And then this is the distribution. If you have a spouse and a child, the first 200,000 plus half of the balance goes to the spouse. If the child is a minor, the official guardian will administer the funds. Right? If a spouse and two or more children, the first 200,000 plus 1/3 of the remainder goes to spouse. The remaining 2/3 will be shared equally by the children. Okay, so that will be the distribution if you die without a will and you have assets. Okay, and then there's like very technical, you know, there's a whole table of who gets what depending on who's alive, etc. Okay? But if you have a will, you can control what happens. Distribution without a will, a spouse and no children or grandchildren, everything goes to your spouse. A spouse, parents, brothers, sisters, and no children, everything goes to your spouse. Right? So again, there's very technical distribution of these things. but it's done for you by the provincial law. So you don't have a say in it if you don't do a will. Okay, sorry, this one here. Distribution without a will, no spouse, no children, equally among the following. It'll be in this order. Okay, but again, you can look this up. It's online. If you go to the Succession Law Reform Act, dying intestate. Okay, dying without a will, then you'll see all the categories. Next, formalities of a will. What's required to make a formal will? There are no legal words needed. Okay, you don't need to have complicated legal words and all that stuff. Okay, you just need to identify the parties, identify the party who this is for, revoke any previous wills. So you say this is the last will and testament of blah blah blah. Okay, and I revoke any previous wills, because you might have a previous will, because then they'd be conflicting, battle of the wills. Okay, witness, you need a witness. Beneficiary or potential beneficiary cannot witness. So it has to be independent witnesses. They don't need to know the contents of the will. They just need to witness you signing it. And then they'll swear an affidavit saying, I witness so-and-so signing this document on such and such a date. They don't need to know, oh, and the distribution said this or whatever. Okay? So the details they don't need to know. A guardian, you need to know who the guardians for the minors will be. A codicil is when you make changes to the will. Okay, so you can add something called a codicil, because you can't make the change on the will itself. You can't cross out things, so you do a codicil. But we always suggest, if you're going to need to do a codicil, it's better just to redo the will. So those are the formalities. I think there's more, is there one more slide? Yeah. Execution, signed in the presence of 2 witnesses. Initial each page of the will except the last page. 1 witness must swear an affidavit. So you'll sign the will on the last page. On every other page, in the bottom right-hand corner, you will initial it, and you'll have the witness's initial as well. And the witness also signs the last page. So if any of those initials are missing, the will not be valid. Why? Because you can insert pages, right? You can have 5 pages, you sign the last page, and people can change the documents, right? Even though it says number or whatever, but people can change. And a lot of fraud happens in this kind of context, okay? 1 witness must swear an affidavit. So that witness will say, I was present on such and such a day with this other witness, and we both witnessed so-and-so signing this will. Here's the person who will administer the estate upon your death. So when you die, this is the person who steps in. Usually people make their spouse the executor, right? The first executor. We usually recommend 3 executors, right? First executor, usually a spouse. If that executor is unwilling and or unable to act, somebody else. If that person is unable or unwilling to act, a third person. We usually suggest that it's, like, let's say, the spouse, and the other 2 people are hopefully a little younger than you. Not that they may not die, but the chances are more likely. If you put somebody older than you as executor or subsequent executor, they may be dead, right? So you want to put somebody younger as executors, and somebody who can manage, because you're putting a lot of stress on them, okay? Because they're the ones who are going to take that will now, and then go to the lawyer, go to the different offices, go to the accountant, do your terminal tax return, go to the lawyer, probably probate the estate, transfer properties. So it's a lot of responsibility on that person. Okay, it's a lot of responsibility. If you're appointing somebody executor, you want to ask them, hey, can I make you my executor? Because they may say, I don't want to do this. Too much responsibility, right? Preferably as someone younger, no executor or foreign executor. If there's no executor appointed, or if the executor is a foreign executor, then the court might request a bond to be posted. So we're just doing an estate right now, where the estate is not much. There's not much money in the estate, but we have to probate. So they have to spend a lot of legal fees in probating. But not only that, because they appointed a foreign executor, we called up an insurance company, how much is for a bond? Okay, so they're distributing $50,000, but the bond is costing them $6,000, and maybe legal fees of $5,000. So $11,000 of the $50,000 is gone, right? $6,000, member or friend usually, family member or friend usually, or as I said, trust company. If there's a lot of complex things, then a trust company or a lawyer is advisable to have as your executor trustee. Okay, a probate. So somebody's done a will. They've appointed their executors. They've said who the beneficiaries are and what they get. They've said in the event that I die with minor children, then I'm appointing these people as my guardian, okay, of the children. Everything is done. You signed off. Person passes away, and they have assets, okay, and they have liabilities and they have whatever, okay. So then you will take it to a lawyer, and that lawyer will then do probate of the estate. So probate of the estate just is a fancy word that says we'll make an application to the court. If there's no significant assets, it's not really, there's no real process. Just filling out a form, filing it in court. Okay? But if there's more assets, there's more issues, then that probate is more complicated. So we're doing a probate right now where a person died, okay? They had bought a property, they had helped somebody else buy a property. That person is in Qatar. They had some down payment money, they wanted to buy a condo. So they sent the money to their friend. The friend signed the condo agreement, right? And after signing, it's a long-term closing. Interim closing is coming a year later on a brand new condo. Important. These documents are very important and they have like significant impact, okay? So probate, it's not always necessary, but you'll have to go and talk to the lawyer at the time of death, and then they will advise you. Say, okay, based on this, I suggest don't do a probate. You can just do it this way. So I've had situations where a client comes to me, they don't have much assets at all. Surviving spouse. They have $50,000 coming to them, okay? Sitting in a bank account in the husband's name alone. Husband's dead. No real estate, no property. Came to us and said, you know what? Let's not probate this. Let's see if the bank will transfer the money to you. So went to the bank, we called the bank and said, no, we need a probate. Why does everybody want probate? Because probate is something the court says, oh, we authorize you as the executor, we're okay. When the court has appointed this person as the executor and the bank deals with them, the bank is covered, right? If they do something without authorization from the court, somebody later can come and say, hey, that was my great-grandfather too, and he said he was going to give me this much money from that too, right? So people come and claim, right? So the bank is concerned. So in that case, we didn't have to do probate, because what we did is we told the client, I'll write a letter to the bank and explain to them the law, saying, look, the first $200,000 goes to the spouse anyway. And we can guarantee you, and we can get you affidavits from all these people saying that she's the surviving spouse, and there's nobody else, no kids, nobody else, nobody's going to come and claim, okay? And the law says this, so we put it all in a letter. So we didn't have to do probate, because the bank's lawyer saw that letter, it was on our letterhead, said, okay, you know what, yeah, that's the law, and they're providing evidence that there's nobody else here, okay? So we don't need to probate the estate, and they gave the money. Probate, there's costs for that. Okay, there's legal fees, depends on the complexities. There's government dollars, okay? If you went and did a proper estate planning advice with a lawyer. But people don't do that, they'll just do a will, okay? And then they'll come, and then now the survivors are hit with lots of taxes, right? There's probate tax, land transfer tax, capital gains on the property maybe. So you have a lot of things get chewed up. That's why the richer people are, then they pay attention to these. Then they'll go and get estate planning, and they'll structure, and they'll do trust, because they have more to lose, right? More taxes to lose. But most people, if you have some property and some investments, it's worthwhile doing like an estate planning advice. They might tell you different things that might work for you. Or it might say, no, that's too complicated for me, forget it. But at least have a will in place that you can then distribute easily with a will. Then what happens is the court appoints a certificate of appointment of a state trustee with a will or without a will. So if you had a will, it's with a will. If you didn't have a will, it's without a will. Okay, so they have differences in power. So where there's no will, certificate of appointment of a state trustee without a will. Okay, following people can apply to be appointed administrator. If you don't have a will, these people can apply, and the list can go on. Okay, if you have a will and you name people as executor, then those are the people who will appoint, who will go to court. Okay, and appointed as executor. Next one. Types of wills. Okay, so lots of people know about the pre-printed forms. So ISNA had this pre-printed form, and I've told them, many lawyers have told them, it's dangerous of doing a will. Same thing when you go to Home Depot or not Home Depot, Business Depot or wherever, and you get those pre-printed forms, okay, they could get thrown out of court, right? Because you're doing a half lawyer job. So it's either the rule is don't pretend to be a lawyer, or go all the way and consult with a lawyer, right? If you don't want to speak to a lawyer, you can do a holograph will. These are the rules, okay? Wholly handwritten. You cannot type, print, pick up a form. Nothing. It has to be in your handwriting, okay? So nobody's forcing you to go to a lawyer, okay? But if you don't don't be a half lawyer, is what they're saying. Don't go to the Home Depot or whatever, Business Depot, and pick up a form and do that, because it may be fine if there's no challenges. But if there's any challenges or issues, that document is going to get thrown out of court. Okay? But if you're going to do it at home, do this will. It's completely in your handwriting, no technical legal language needed, just a simple will. Okay? You don't call up a lawyer and say, I'm doing a holograph will, what should I put in it? Right? But then it's not a holograph will. Right? A holograph will mean just in your handwriting, in your language, saying, I am writing this as my last will and testament. You know, I want to be buried Islamically, I blah, 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 whatever you need to say, and then I, appoint so-and-so as my executor. If they can't be my executor, I appoint so-and-so as my executor. So very simple English, okay? You don't need witnesses. So a person dying can write a holograph will, right? Because we don't want to impose all these obligations on people and say, I can't afford a lawyer, I can't do this, so I can't do a will. No, anybody can do it. You need to speak to scholars here, how does it comply with Islamic rules? But legally, okay, so this would be fine for you to do, and you can distribute it and you sign it. That's it, okay? But if you want to do something more formal, then don't do these things, because a couple of things, it could be challenged. Secondly, people do it, and then they forget to do the affidavit because they have to run to a lawyer to do the affidavit, right? So they don't do that. Affidavit or witness, okay? The formal will is what you would go to a lawyer for, and of course there's legal costs involved, and then we'll make sure that all the formalities are followed, but more importantly, we'll sit down and chat with you. Because you'll tell us certain things, we'll say, hey, whoa, hang on a sec, you don't want to do that. Oh, you're trying to do that? No, don't care after that? Because you think you're going to die first and your wife is going to do her will properly? You can do a simple holograph will. Okay? But then that means if you don't die first and it doesn't go to your wife, then the whole dynamic changes now, right? Because now you just had a simple will. Okay? So it all depends what you want to do. Okay. The next one. Okay, so the wills are done. I'll turn to some questions in a minute. I'm just gonna address two other things that are important. Power of attorney for personal care, power of attorney for financial affairs, or these two documents are very important, right? Because the will only comes into effect upon your death. But many people, before they die, they're in a state where they cannot make decisions anymore. They can't leave to go to the bank, they can't do certain things. And it's too late at that time to call the lawyer and say, hey, I need a power of attorney. Because the lawyer is going to speak to whoever it is, say, well, this person's not competent, I can't sign a power of attorney. Right? You need now to get a court order. And to get a court order is going to be very expensive. Basically, the court will have to order a power of attorney done. Right? If you have any questions, I think if I get questions, I might be able to narrow in on specifics that you might have. Yep?
You said there are a lot of challenges that can be done on a will.
Yeah.
So if you make a will and it can be per se challenged for sure, what is the benefit of the will?
Good question. So the question is, if the will can be challenged, what's the purpose of it? So challenges are going to be the courts are open for anybody, right? Anytime, any document you have, anything you do, it can always be challenged. You can always be sued. Okay, there's nothing saying that somebody, whether it's going to succeed or not, is going to be the issue, right? So first of all, when there's a will, many of the potential claims to the estate, people just walk away. Okay, a lot of times we would have people would come to us and they say, well, we have this, we have that, we want to do this, and then we'll write to the lawyer or write to the other side, and then they'll send us a will copy. Okay, then the person, okay, forget it, okay, it's done, right? It's done. So it gets rid of a lot of the disputes. Then there's certain things in the the will that might open up for this. So for instance, your spouse might say, well, I don't want the will, I want to take under the family law act. Okay, that's unavoidable because the family law gives them that right. Okay, but majority of the people have had this discussion with the spouse and they're okay with it. So they don't challenge it. They just say, okay, we both agree that we respect each other's wills. Okay, then other things, people coming forward and challenging, somebody might say, well, I was a dependent and I'm not in there. Well, at least you have the will, so that's evidence for us saying, look, in the will, there's no mention of this person, right? So we already in a positive position with a judge, right? So Your Honor, this person had no intention at all because there's nowhere in the will, right? They might present other documents, but then those documents may be 5 years before or whatever it is, right? But the fact that you have a will is going to be in your favor, right? Because that's some evidence that already establishes that, look, this is the latest intention of this party. If they provide other evidence, at least we have a will that says, no, look, their name is not here. It's for them to prove that this should not be. So you still, the fact that you have a will is to your advantage. All challenges, the fact that you have a will is going to be in your favor, right? You have.
I mean, after the will day, does it make any difference? If the will is old one, if dependent has a document that says, the latest one, does it have an impact?
Then it all becomes based on the evidence and the credibility, and it might become a trial, right? Or usually most matters, they'll get settled. Okay, so it might be like that's the litigation process where you're bringing evidence, and the parties will sit down, and maybe it might not go to trial. It might be in a pre-trial motion or some kind of preliminary hearing or something where they'll agree to settle or walk away or what, But the fact that it's dated after, yes, it's going to be to their advantage. But then you're responsible for it's made up. It's not his signature or whatever, right? So the equity is there. So your family's living in the property. What should happen with that property, right? Well, if you're the sole person who's paying the mortgage, the bank is going to make that decision for you. The bank is going to say, hey, get the hell out, right? Refinance or sell it and pay us back. Right, so you will have some equity there. So you need to figure out how it's going to go. If you don't specify and write a will, then the Succession Law Reform Act kicks in, which is what I told you, which is the spouse and the children, they would get it. Okay, but then you have to. The probate is a little bit more complicated. Applying to the court when you don't have a executor, when you don't have a will, it's a little bit more complicated than doing it without with the will. Sorry. Okay. Okay, so the first question about the property overseas. We usually, in our wills, we say property wheresoever located. Property doesn't mean, real property. Property in the will language is property, all assets. Okay, so we basically say all properties wheresoever located, you're distributing like this. But foreign countries might say, well, no. The rule is, for our properties in our country here, you have to do a local will, right? Because the law of wills is the law of domicile. It's called the law of the law where you're living and where your property is. That's the law that's going to be applicable. Okay, so some countries will allow foreign wills to apply, but I don't think India does. India will have its own rules, right? So you have to. We suggest do wills both places. But just put a clause saying my property wherever located. Okay. The second question is if you have property now and then you buy something else. So we always suggest to our clients, don't list your properties in the will. Because then every time you buy and sell, it's good for us, but not good for you, right? So the best thing is you'll say property wheresoever located. Whatever property you have. That property basket will increase, decrease over time. Okay? Your passwords, because passwords are very critical. We see lots of people, they have no access to anything, right? Because all your passwords should be somewhere safe, right? I don't want to tell you to put a list with it, but maybe put something somewhere where they can access it or give them some clues or whatever, right? That they can get it, because that's critical, right? So if you have that list of assets changing, then you can keep changing that list. And it's kept with your... Because the way the will is written, it's whatever is in my estate. That estate will grow and reduce and increase, and for from time to time. Okay, so that's the way. That means your future assets are also included in this. And then you'll have clauses depending. You might say the matrimonial home will go to my spouse. So the law of the land is basically what's going to govern. So if you don't have, whatever your situation is, will be governed by the will that you write here, or by the Succession Law Reform Act. Okay, so that has, it'll go to your children. If you don't have anybody else, and you can do a will that says I want it to go to my children. If you want to give something to whoever, you can specify that illegally. Okay, Islamically you can talk to scholars or whatever, and then get your formulation as to what you need to do. Right?
So even if you have a property back home, which will not be governed.
Oh, so back home, that's going to be, so I think they govern things according to Muhammadan law, they call it over there, right? So, which is an interpretation of Sharia law, right? So, that would happen over there. I don't know what, you'd have to talk to maybe a scholar there or a lawyer over there. A lawyer over there would be able to tell you, this is what the scheme of distribution is.